Tanya Rowden versus Royce Inman.
Court will note that this matter is before the court on the defendant's objection to a motion to set aside referee. In this matter, Mr. Inman, you can proceed.
Okay. Yeah, so I'm trying to get visitation rights for my daughter because I haven't been able to see her at all in the last 2 months.
Okay.
And I kind of want to get that, see if I can get that 270 lowered because now for one, I'm having a lot of trouble right now with my expenses where I live, and I got another kid on the way, and it's just things are real tough right now.
Okay. Well, in this matter, as it relates to the support, the court will not, you haven't set forth any basis to modify that. And obviously, as you said, yes, it's difficult, but if in fact the support is calculated correctly based upon the incomes, then again, the court would not modify that unless there was some other issue. You stated you have another child on the way. Once that child is born, then that would be a basis to modify the support because you would have another child, and that should be taken into consideration. So that would be a basis to set it aside, at least to modify the support. Ms. Roden, what's your response?
I think the referee did a good job on the determine the visitation rights and all that, I mean, about her, but I still feel that if she goes over there, it'd be fail to her safety being over there without someone supervising because he's legally blind and he has not have hardly nothing to do with her when he did live with her. I just feel like it's a safety issue.
Okay. Mr. Inman, anything else?
Yes, sir. I'd like to include, when I lived there, she was getting all this going for the courts when I was still living with her. And I want to mention too, sir, the reason why I say that it's been real tough on me because when I lived there, when I moved out, she stole all my money, a boatload of my money.
Okay. Well,
and
okay. That's not what we're looking at is the issue of support. All that other is extraneous that you have to file some other action. That's not something the court will decide today.
Correct. I'm in the middle of that right now. I'm trying to handle that. So yeah, I'm in the middle of that.
Okay. Okay. Well, what we're going to do in this matter is, again, court will only set aside the referee recommended order if in fact there's a factual or legal basis for doing so. The court doesn't see that based upon either the pleadings or the argument today. So I'm going to deny it at this time with the fact that Mr. Inman, when the other child is born, you have a right to seek a modification at that time. And so that's up to you then. So that will be the order of the court, and you're free to go. Have a good day. Court will note the appearance of Ms. Reed on behalf of plaintiff. This matter is before the court on the defendant's objection to the ex parte order. Mr. Hauser, in this matter, in the plaintiff's response, they acknowledge and state that in this case that obviously this matter was addressed on 12/9 and 12/16 at hearings at those particular dates. So why should the court look at this a third time?
Your Honor, I prepared a statement. If I could read it, please.
If you could what?
Read a statement I prepared.
Go ahead.
Your Honor,
Provided it's not a novel. Be succinct.
I missed my court date on the 9th due to Courtney not updating her attorney on my newest address, even though she signed a document stating she reviewed all the information and that it was correct to the best of her knowledge. I have lived at my current address for almost 3 years, and Courtney has been to my home multiple times and has even mailed packages on different occasions. She is well aware of my current address. Tristan, the child that we're speaking of, has had no signs or symptoms of being suicidal until he was put on these mood-altering medications, which was done without my knowledge. His first suicide attempt came after starting the medication, but before any parenting time was spent with me. Prior to being prescribed his first mental health medication, Tristan was being treated for only situational stress. The custody agreement states joint legal custody and that major medical decisions must be discussed between both parties, and I was never involved in the decision to medicate Tristan. Tristan's issues only occur while in Courtney's care, and she has never been upfront and truthful about what is taking place until after the fact, and even then does not tell the whole story. Courtney has even instructed both the children to lie to me in the past and say that Tristan is not being violent towards her, which he still is according to his medical records. Tristan has never had any type of behavioral issues while in my care or that of my family members. Tristan's medical care has been flawed from the start due to Courtney lying to medical staff and leaving out important factors that would impact his treatment. I believe Tristan staying in Courtney's custody is a danger to his life, especially now after his second suicide attempt, which I still do not have the full details of because Courtney refuses to communicate with me. The only information I have about the incident I have gained from his medical records. That's all I have, Your Honor.
So you do have medical records on that,
Yes, Your Honor.
and you are able to speak with the doctor then at that point, sir?
I have the records, but I have not called the doctors.
Okay. Well, maybe you need to do that and set up an appointment and talk to them and
Yes.
relate some of your concerns, et cetera, so they have that information available to them. I do note that the matter is set for evidentiary hearing on February 11 too. Is that, you understand that?
Yes, sir.
Okay. Ms. Reed, is there anything else that you have?
Just that we've already addressed this matter twice before the court, and this hearing was not necessary. And so we are requesting that the objection be denied, and we're requesting attorney's fees of $525 as this was a frivolous objection.
Okay. Well, I know, and these issues are difficult when parties are self-represented and they don't understand some of the intricacies at this point. The court notes that there is an evidentiary hearing where we'll address a lot of these issues. And Mr. Hauser now acknowledges that he does have the medical records available. He could, in fact, meet with the doctor. So I don't see that as being an issue, but I would state that obviously when the parties do have joint legal, they need to communicate with each other. And if they don't, the court could step in and again, cancel any medication or medical procedures that are occurring if they don't communicate as they're required to do. I'm not going to do that at this point until we have an evidentiary hearing in this matter. But what I'm going to do is I'm simply going to reserve on the attorney fees at this point, and then we'll proceed with the hearing in February and see if we can't resolve everything at that time. So that will be the order of the court. You're free to go. Have a good day.
Would Your Honor like me to prepare the order on that?
Yes, please.
All right, thank you.
Court will note that this matter is before the court on the plaintiff's motion for entry of final judgment of divorce and UCSO in this matter. Mr. Osborne, what's your response, if any, to the motion?
Well, I contest it. For many different reasons, I still have not been able to get any of my property. The last order that you granted, I went out there as you said to do, and the pole barn was unlocked, so knocked on the door, nobody was there. I worked on the pole barn and getting everything as much as I could out of it, but it had been gone through and it looked like somebody just ransacked it and knocked all my stuff all over. There was stuff that was missing that I had no way to find out who took it, or because there's no way to talk to Mrs. Osborne. She's made that impossible. I cannot continue. I can't pay $2,200 a month for a house payment and child support and live on my own. There's just no physical way for me to do that. Being taken out of that environment, that was my work. That was where I lived. That was where I worked. So basically I was eradicated from that house with all of my stuff there. And I'm still trying to recover from that. Not being able to work for 60 days because Mrs. Osborne would not grant me rights to my tools. It cut my head off. There's no way for me to make a living. I tried to find jobs, can't find one. So I'm still trying to go through that.
Okay.
Sorry, go ahead.
Okay, Ms. Osborne, what's your response? Or Miss Osborne.
He's muted.
You're muted, ma'am. You have to unmute.
Sorry about that, Your Honor.
Go ahead.
My response is that Mr. Osborne has been out several times, not only invited, but uninvited. He has been here to get his property over the last few months, so many times I can't even count.
Okay,
And
well, what about the I don't care about all the other time. What about the last time?
the
when
last
you
time
previously ordered it?
he came out here at 1:30. I left the barn unlocked. He went in there to recover his items. He was here until December, until almost 3 in the morning, when the police had to make him leave. And they had to make him leave because he decided to take a drill to the front door and drilled through the handle and the deadbolt, ruining the whole front door. So, which put me and my children in the hole for Christmas. We were unable to have a Christmas because I had to pay for that. Every time he comes out here, it's to harass me. I have given him everything and I can't take this anymore.
Okay.
He's just trying to find a way to hang on constantly. Nobody has taken his things. In fact, the trailer you told him to get, the Stowe concrete machine, everything's still here. He won't take it.
Okay. Well, what happens is the issues before the court for the entry of the judgment in the UCSO, court has not been apprised of any reason that the court shouldn't enter that. There may be issues that relate to enforcement or that, and that could be, again, subject to later petition if the parties wish to, again, dispute or contest that, that's fine. But for today's date is just whether we enter the judgment. Court does note that court had previously had a trial on this matter, had ordered this, so there's no claim that it's not consistent with the court's ruling. The court will enter the order, the judgment of divorce in the UCSO as submitted in this case, and that will conclude the matter today. And you can proceed with other action if you wish to do so, if you have a basis to do so, by filing a motion to enforce the judgment. So that will be the order of the court. You're free to go. Have a good day.
Your Honor, may I ask you one question?
Go ahead.
Okay. Do I have to file a motion because Mr. Osborne has decided to run this house, our primary house, into foreclosure now? You've granted him 2.5 houses and
Well, you have to file a motion to seek enforcement of the judgment. So if he's doing things that are inconsistent with the judgment, yes, you have to file a motion for the court to take action on that, because the other side is entitled to due process notice. You just can't bring it up at a hearing now saying, okay, I want to address this too, because they don't have notice of what they're required to respond to. So file your motion. The court will hear it at that time.
we'll be in foreclosure within 2 days, Your Honor. So
File your motion. The court will take care of it at that time.
thank you, Your Honor.
Okay. Court will note in this matter, the court had a trial back on November 5th, 2024. Apparently, the plaintiff had submitted various judgments to the front of the court, and they had objected to those. And the plaintiff has now filed a motion for custody. Is that accurate, Ms. Daniel?
Yeah, I just they were helping me out. I just redid it. They told me how to do it the right way, so they have it.
Okay.
Yeah.
Go ahead on your motion for custody, ma'am.
Okay, so the evidence I sent to you, he's being charged.
Okay, ma'am, you didn't send any evidence. I don't take evidence in these matters. I'm doing it based upon your motion at this point.
Okay. He's being charged with 3 accounts of operated with occupants less than 16, which is my children. I got a letter from the prosecutor attorney. And he's being charged with 1 account of a high BAC. The court date is January 7th at 9:00 in the morning, and I'm going there because they want me there. I have to talk to the prosecutor attorney. And then he just showed up on the 18th when it was time to pick up Lorenzo. He showed up drunk. His ex-girlfriend Audrey had called me and told me not to give up the baby because he's been drinking, and he went to jail that night for drinking. And I had all the kids.
Okay. What's your response, Mr. Daniel?
I am so confused on everything that's being said right now.
Well, it's not that confusing. She's claiming that you're charged with a OWI and that you're going to court in about another week or so. And that you're also charged with wait until I'm done. I'm not going to interrupt you. Don't interrupt me. You're also being charged with transporting children less than 16 years of age. So those are her allegations. What's your response?
This is the same exact court order from May 9th of this year, which I had my TBI,
Okay.
in which case that is where my confusion come in at, because as far as I know, when we had court ever since May 2024 of this year, it, it was all good.
Okay, so it's not a new charge or anything, sir?
No, sir, this is the same exact charge where she got temporary
Okay,
custody. I
okay,
am really confused.
okay. Well, what I'm gonna do, ma'am, is you've resubmitted. Hopefully we have the front of the court will give its approval. If they do give the approval, the court will enter the judgment in the UCSO as submitted. If in fact there's anything that you have since, again, the time of the trial on the November 5th date, anything since then you always have a right to petition to modify, and the court would take that into consideration. But at this point, if that offense predates the trial in that, the court has already addressed that with the judgment. So
I'm so sorry. I don't want to be rude, Your Honor. I have a question because you say November 5th. I've never had none of that. So I'm trying to figure this all out.
our trial date.
No, I've never had a trial date or anything.
Sir,
Hold on. We're looking it up to see the date. Okay, that I had it wrong. The trial date was November 5th, in which both of you appeared, and we went through everything. Maybe you have your dates wrong, that's all.
Oh, are you talking about for the case prior to this?
No, about our case.
Our case.
About our case.
Oh, okay. I'm so
I'm not
sorry.
talking about any
That's-
other case. I don't know about any other case. It's not on my docket. I'm talking about our case.
Okay, I apologize, Your Honor. That's what I was trying to figure out. I'm like,
No problem. So the court will enter the judgment, and then if you have a basis, ma'am, for modification of the judgment, for anything that occurred after that date, the November 5th date, the court will consider it. So that's up to you, but that's what we're gonna do at this point.
okay, yeah, because what he's being charged with is new. I just talked to prosecutor attorney the other day.
I have no idea. I can't guess at this. If there is, you have a right to file a motion at that point to modify the judgment that we will enter. But I want to get that judgment entered at this point. If there's something new, refile it then at that point. Okay?
So what do I do
Your
with
Honor.
this case in the meantime? They
Well,
just-
you have to comply with the ruling of the court, and that would be to provide him with custody and parenting time as provided under the proposed judgment.
What does that mean?
It means you have to comply with the order. The court ordered custody in this matter, the court ordered parenting time. You have to comply with that until such time as it's changed, which means if, again, there's a basis for change, the court will consider that, but you're gonna have to set forth that in a motion, and then he has a chance to respond, and then we will address it. Okay?
All right.
Court will note the appearance of Mr. Snyder on behalf of the defendant. We have competing motions, the defendant's motion to amend final consent order as well as plaintiff's order in this matter. Mr. Snyder, we'll let you proceed.
Good morning, Your Honor. Yeah, this is a defendant's motion to amend the consent order regarding child support. She's had substantial financial changes since The order was entered in April in this case, and we're asking for a review of the situation, whether with your Honor's court or friend of court, to readdress the child support situation in this matter.
Okay, thank you. So just the support issue then, Mr. Snyder?
On our side, yes, Your Honor.
Okay. Mr. Luke, as to your motion, you can proceed.
Your Honor, if I may, I would like to clear the air on a few facts. Maya is consistently late, sometimes after 6:30. Once again, I have been informed that Maya does not have auto insurance on her vehicle. Maya has constantly failed to provide medication, including treatments for Summer's infections during our exchanges. Maya has constantly failed to inform me of medical visits or inform me of aftercare visit summaries during our exchanges. On November 13th, Maya posted on social media asking strangers to watch our child. On November 27th, Maya posted on social media of marijuana while Summer was in her care with hashtag Blackout Wednesday. On December 8th, Maya was intoxicated and hungover while taking our daughter to see Santa Claus. On December 14th, Maya arrived at 6:16 p.m. On December 18th, Summer had another diaper rash. On December 24th, Summer had a significant diaper rash spreading to her thigh, also had multiple scratches on her lower back. Maya has made numerous statements about how she can't stand Summer and that I can have her. Maya recently asked for a lighter during the exchange and proceeded to smoke a joint. I have acquired medical, vision, and dental insurance for our daughter, which starts tomorrow. Your Honor, I am deeply concerned about my daughter's safety and well-being as evidenced by the facts I presented today. My sole focus as her father is to provide her with a safe, nurturing, and stable environment. I respectfully ask the court to consider these concerns and grant the necessary changes to protect her health, stability, and future. Thank you, Your Honor.
Yeah, thank you. Mr. Snyder, any response?
Yeah, Your Honor. Everything that Mr. Luke just stated is denied. The text messages allegedly attached to his motion were not even sent to him. Those are all between my client and our mother. My client is not consistently late. Every now and then, either party will be a couple of minutes late. No worries, as long as it's consistently around 6 o'clock, which it is. And regarding the scratches, my client has a cat. Cats scratch. You know, there was no significant damage done. I mean, I've got a cat, and my cat scratches me. It's just what cats do. My client provides medical treatment for the daughter, and she informs Mr. Luke of the situation, just as he should do to her. There's no reason for a change in primary custody in this case, Your Honor.
Okay.
And I would like to ask, on the record, Your Honor, Mr. Luke, can you let me know if your uncle Michael Luke has prepared your documents that you filed?
He has not, and I also provided the court with a verified statement.
Okay.
Did you provide that to me?
No, I did not.
That was filed with the court?
It was filed with the court on Friday.
And why in your motion are you asking for attorney's fees and costs if you're unrepresented?
The reason I asked for that is because my intention was to retain Mr. Miles Murphy, and he has encouraged me that I have a strong case and encouraged me to attend in pro per.
Okay. Well, sir, you can't get attorney fees if you don't have an attorney. So that's an easy one to address. What the court is going to do is the court does find, as it relates to the defendant's motion, there's a basis for, again, to have a review. The court will send the matter to the referee for a review of child support. I will let the parties know as well that at the exchanges, and I don't know what the time is, that the court provides that the parties have to remain at the exchanges for up to 30 minutes for purposes of that exchange. If it's over that, then they have a right to leave if they're waiting to, in fact, make the exchange, and the person that's going to pick up the child, again, forfeits that if they're not there within 30 minutes of the exchange time, and which would be 6 o'clock p.m. in this case. The court doesn't find, based upon the allegations, that the plaintiff has met the Vodvarkas threshold of proper cause or change in circumstances sufficient for an evidentiary hearing. So the court will deny the plaintiff's motion in this matter at this time. And we'll refer the matter to the referee on the issue of support. So you're free to go. Have a good day. Court will note the appearance of Ms. McNiff in this matter. The matter is before the court on the plaintiff's objection to the defendant's exhibit list submitted on 12/19/24. Ms. McNiff, I don't know why you felt it was necessary to file a motion. You could have done it when we have our hearing this week.
I just was concerned about the timing of it and wanted to make sure the court understood that we were going to be objecting to all of those exhibits.
Okay, again, we could have done it on Friday when we have the trial. Mr. Olapide, what's your response to their objection?
Your Honor, my response is that do we have the same right under the law, both the plaintiff and the defendant? I consider this as my amendment to my exhibits list. On the exhibits list that the plaintiff submitted, they said they reserve the right to amend their exhibits list. I just amended mine since the trial is still ongoing. I really don't, like Your Honor said, I don't see any big deal there.
Okay, well, what happens in this case, if you remember, you go back to the case scheduling order. The case scheduling order had some deadlines as to when those lists were due. At that time, you were represented. Your attorney did file a witness list and an exhibit list. And this amended list would not be timely and not consistent with the case scheduling order.
Your Honor, I wasn't represented by any attorney for this trial. I discontinued with my attorney when he defaulted before this trial was even set. So nobody gave me any scheduling order.
Okay, well, your attorney filed one, and so you were represented, and regardless of whether you're represented now or not, you're still bound by that case scheduling order, and you've missed the date for filing that the list of exhibits.
I wasn't informed. I just want the truth to be told. The plaintiff wanted to paint me as an abuser.
That's fine. I understand you want the truth to be told, but that's why we put those dates in place so that the truth can be told and everybody has an opportunity to respond and get their appropriate witnesses, exhibits, etc. The court is going to enforce its orders in this matter. The court will grant the objection and deny the admission of the late exhibit list in this case, and that will be the order of the court. Ms. McNiff, you can do an order submitted under 7 days.
Thank you, Your Honor.
Court will note in this matter, appearing on behalf of the plaintiff, would you restate your name again, ma'am? Plaintiff's counsel?
Lauren Peters.
Peters?
Yes.
Okay.
Peters.
Okay, sorry. Couldn't hear. And court will note Mr. Schaefer on behalf of the defendant. This is before the court on the defendant's motion to adjourn the evidentiary hearing scheduled before the referee on January 6, 2025. Mr. Schaefer.
But please, the court, Your Honor, I was retained on this matter on December 18th. I immediately called opposing counsel's office and talked to Aaron Jansen requesting an adjournment of the date that this was set on January 6th, which is a motion day to begin with. I have 8 matters scheduled on the 6th with possibly 4 different judges that run from 9 o'clock until 3:30 or 4 o'clock. Also, the time period, we have complied with the scheduling order for the disclosure of witnesses and exhibits. I believe that it's good cause to reset this matter so it has sufficient time not only to prepare, but the schedule is such that it's going to be impossible to deal with 4 judges and referee is going. This is scheduled for a whole day on the 6th. So I'm respectfully asking the court to find good cause that this matter be rescheduled for a time that's convenient for both sides.
Ms. Peters, what's your response?
Your Honor, the defendant has been seeking legal counsel or has claimed to seek legal counsel since September of this year, and he waited until 2 weeks before the hearing to obtain legal counsel. When we spoke to Mr. Schaefer's office between October and November, they had said he was not a client. At this point in time, it would be highly prejudicial for the child and my client to adjourn. Our witnesses have been subpoenaed, and these issues have already been delayed countless times. So we would just ask that it not be adjourned.
Okay, thank you. Well, in this matter, the court is, again, not inclined to adjourn these particular matters, but as Mr. Schaefer states, he has only recently been retained. He has a number of conflicts, and I think it's for purposes of fundamental fairness would be only appropriate to adjourn the matter. Although it might have been better to bring the matter before the referee as opposed to me, because it is a referee hearing, but the court will adjourn the matter, and then you will get an alternate date and you can proceed at that point. The court doesn't see any prejudice in this matter with allowing the matter to go over a few more weeks. So that will be the order. Mr. Schaefer, you can prepare the order.
I will do so, Your Honor. Thank you.
Okay, thank you.
Thank you, Your Honor.
Court will note the appearance of Ms. Boland on behalf of the plaintiff, Ms. Rosenzweig on behalf of the defendant. We have two motions before the court. The motion for entry of an order of affiliation, as well as a motion for custody, parenting time, and order of affiliation in this matter. The court will note staff has advised me, and I guess I wonder, first issue is the jurisdiction, as we have plaintiff resides in Wyoming. Defendant resides in Kalamazoo. How is the case properly before the court in Calhoun County?
So at the time of filing, Your Honor, defendant was living, well, upon information and belief, was living in Calhoun County, and that's where the child was born as well. Defendant's residence is a little up in the air. Okay. Ms. Rosenzweig, was the defendant residing in Calhoun County at the time the action was filed?
No, I believe she was living in Kalamazoo County at that time. She was living in Kalamazoo, and the baby was born in Calhoun County. And we filed our adoption petition in Calhoun because baby was born there.
Okay, so we do have the adoption petition.
Yes, Your Honor, and I believe there's also an open NA case in this county.
There is no open NA case. We've checked. So
okay.
There was never an NA case, because the child went directly to the adoptive parents, and the child is in Colorado now.
Well, what I'm going to do in this matter is court is not going to address the motions at this point. First, I'm going to order that the adoptive parents be joined so they have notice in this particular matter, and I will reserve everything else pending further hearing. I do want, and I'll ask that the both of the attorneys in this matter would submit some briefs as it relates to jurisdiction, because I do have some jurisdictional issues that I want to resolve prior to the hearing in this matter. And we will be in touch with both of your offices to find out when you're available, and it'll be off enough such that we can get service on the adoptive parents as well.
Your Honor, if I may, my client has already signed an acknowledgement of parentage with Mr. Hill, and these adoptive parents have had custody of this child since October, and they are willing to return the child to Mr. Hill if the orders could be signed. We don't want them to have to care for this child any longer than they need to. It's just heartbreaking for them.
Well, I understand that, but I'm not going to sign an order at this point until we have all these issues resolved, and we should be able to get you in a few weeks. So I don't see that's going to delay it too much more. So.
Well, and Your Honor, I was thinking about the potential jurisdiction issue, because the way this case started was unique because of the situation. So we filed in Calhoun because we knew the child was born in Calhoun.
I understand.
But what I'm saying is I might, considering knowing now that mom isn't at least currently living in Calhoun County, I might just refile in Kalamazoo County to expedite things and to get over the.
Well, you can do
jurisdiction.
what you want to do. Be in contact with Ms. Rosenweg to communicate with her as well. And obviously, I would do again the order of notice to the adoptive parents.
Yeah,
Again, it
we've been
sounds like
giving their attorney actual notice this whole time.
okay. Well, do that. We'll be in touch with you, and it might be best if you refile. It might be easier that way.
Yeah.
Okay.
As well.
And then you'd have to dismiss this action then too.
Yes.
Okay. Be in touch with Ms. Rosenzweig and see if we can't get something worked out in that regard.
Understood.
Thank you.
The plaintiff is not here.
Okay. Mr. Campbell, we note that this matter is before the court for a status conference. We were monitoring it as when we were in court previously on November 6, 2024. Plaintiff stated at that time that she was going to file the revocation of paternity action. She has not done that at this point. So what's going to happen? I don't know. Have you filed a counter complaint for divorce?
Believe I have.
Okay.
I can check that here.
Yeah, Mr. Flores, I don't have.
It does look like it. Let me just confirm.
I know that I'm the one that filed for the divorce.
Well, you're not. She's the plaintiff, so.
Yes, his answer is listed September 6, 2024 as a answer / counterclaim.
Okay, you filed the counterclaim then. What happens is she was supposed to file a revocation of paternity action, which she has not done. Are you going to pursue that, sir?
Pursue what?
The revocation of paternity action.
I don't even know what that is.
Okay, well, what happens when you're claiming that a child is not issue of the marriage, you have to file a revocation of paternity motion in the case, asking that the court would determine that a particular child is not issue of the marriage and is a child born out of wedlock. That's what she claims she was going to do, but she hasn't done it yet.
She's full of it.
Okay, I'm just wondering if, in fact, if you believe that that's necessary. If not, then what happens?
I'm pretty sure the child in the marriage is mine.
Okay.
He lives with me. He acts just like me.
Okay. Well, is that good or bad, sir? Okay. Depends on the day.
Flexible.
Huh? Okay.
It depends on the day.
Okay. Well, what's going to happen is we need to get a judgment of divorce prepared. You'll have to, because she's not appearing today, but the intent was that now that we know you filed a counter complaint, we can proceed on your counter complaint, but you're going to have to prepare a judgment of divorce, a uniform child support order, and a judgment information form, those 3 documents. You can go to michiganlegalhelp.org. It's an online service, and put in there that you want to complete the divorce, and it'll take you right through the process. You fill in the blanks on those documents, and then at the end you hit print, and it'll print those out for you. Okay.
Okay. I think I got that.
What's going to happen? We've got a few days left. We have to get it completed, or otherwise, if we don't get it completed relatively soon, then the court will dismiss the case. And then you'd have to file it all over again and do that. So
that's what's happened the last few times. We've been trying to get the divorce done.
Okay, well, let's hope that you can get it done and we don't have to do that again. But obviously, we can only keep the case pending so long, and then it happens we get out of the time deadlines in this matter, and then the state comes back and starts harassing us if we don't get them done within a particular amount of time. So
I just want the divorce. Me and her's been separated for.
I understand, but you have to have those documents to complete it or we can't complete it.
I know.
Okay.
Paperwork.
Yeah. So again, it's the judgment of divorce, the uniform child support order, and a judgment information form. And those, again, they're all on the site at the michiganlegalhelp.org. So if you get in that, get that prepared, I'll set this matter for a follow-up status conference in about 30 days. And then hopefully you can have it done within that time and get the approvals, because it has to be approved by the front of the court. And then we can get the matter completed. So I don't.
Make sure that I get these documents right.
Okay.
He's saying that I got to follow these documents, these papers, that I want to make sure I got the right paper. What was the papers again?
Okay, write it down.
Yeah.
One is a judgment of divorce. Next is the uniform child support order and a judgment information form.
The uniform.
Child support.
Child support order.
Okay.
And a judgment information form. All the judgment information form is information about you and her and how to contact both of you, addresses, phone numbers, in the event that the front of the court needs to contact you.
Judgment info. Okay.
And you can find all of that at michiganlegalhelp.org.
Or
legalhelp.org.
Legal help. .org. Okay.
Okay, get all that prepared, and when you have it prepared, you'll have to submit it to the front of the court for their approval, because they will review it and make sure that everything is in order. And if they give you the approval, then after the 180 days, we'll be able to complete the case.
Okay.
So you have 40 days left for us to get all the paperwork done, et cetera, so that we can get it completed.
Okay.
Okay, we'll get that prepared, and then we'll see you back in about 30 days and check up on it to see where you're where you're at and what's being done. Okay.
All right.
Okay. Thank you. You have a good day, sir.
You too.
All right, thank you.
It's my understanding that Mr. Thrasher would have legal custody and physical custody of the minor children. Parenting time would be as agreed. And then
okay, hold on again. I didn't hear it initially, so I want to make sure I get that correct.
Correct. Your Honor, there would be Mr. Thrasher would have legal custody and physical custody of the minor children. Parenting time would be as agreed, and there would be no child support paid in this matter.
Okay.
And that's the totality of the agreement.
Okay. Ms. Thrasher, you've heard the agreement as stated by Mr. Todd, which would provide, I'll just recite that to make sure that the plaintiff in this matter would be granted the legal and physical custody of the children. Is that correct?
Yes.
And that, in fact, you would have parenting time as the two of you could agree to.
Yes.
And that there would be no support. You wouldn't be required to pay any support. You understand that?
Yes.
And is that agreeable to you?
Yeah.
Okay. And I'll ask you, Mr. Thrasher, you've heard the agreement is placed on the record. Is that acceptable and agreeable to you?
Yes, Your Honor.
Okay. And Mr. Thrasher, do you believe that it's in the best interest of the minor children that we proceed in this matter?
Yes, Your Honor.
And Ms. Thrasher, do you agree as well? I didn't hear you, ma'am. I'm sorry.
What was the question?
I said, do you agree that it is in the best interest of the minor child that we proceed with this settlement and resolution?
Yeah.
Okay, thank you. Well, with that, those are the issues before the court. So the court would accept the agreement of the parties. I'll ask that Mr. Todd would prepare the appropriate order to reflect that agreement. Ms. Thrasher, Mr. Todd will send that to you. And as a result, he'll send that to you for your approval, and you can sign that and send it back to Mr. Todd, and then we'll get it entered at that time. Okay?
Okay.
What address did we send to hers?
The last, let me double check, Judge.
It was the Aiden Lane.
14 Mile Road?
Yes.
Okay.
Okay, ma'am, if you would, I don't take it off the record at this point, so it's not.
Yes, okay, let me pause it here. 1 moment.
We're taking it off the record so that you don't have to disclose your